Hi. Today I'd like to talk about a legal case that was happened in 2010. It's called Belsky versus Capos. So this was a legal case that settles the argument that the machine or transformation test is not the sole test for determining the patent eligibility of a process. So eventually the final result was that the Supreme Court rejected this patent application on a method of hedging losses by making investments because this is an abstract investment strategy such that it is not patentable. So so I went ahead and actually tried to did a little bit of research on understanding what's going on and what is this machine or transformation test. So basically, this test requires a process to be tied to a particular machine or apparatus or or transform an article into a different state or thing in order to be patentable subject matter. So to file a patent to see if your patent is patentable, um, you either fail this test or you pass this test. But this legal case tells actually determines that even if you fail this machine or transformation test, it is okay. Is your patent is still considered? It might be considered patentable under certain circumstances. Um, so actually, this caused a little bit of debating on whether a software is whether a certain kind of software is patentable or not. Um, so I actually found this article really interesting. It actually talks about, well, as a software developer, um, the core, the most valuable things in a software is the design. Like the 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 part that's patentable is where the design goes, how this has been done into code. So transform your idea and design into code. Um, so this raises the question of, can you actually have a design and you haven't implemented yet in code, but you can patent this design? So would that be considered an abstract idea where it's not patentable? Um, so this is interesting, and then it's definitely the Supreme Court and then the Section 101 definitely needs to clarify the eligibility of what is patentable and what is not. And I think there's also another cases going on, which on my blog I talk a little bit about. So it's called, let me look it up real quick. It's called the Alice Corporation versus CLS Bank International. So it is also another similar cases where they're debating on whether their financial trading system is patentable or not. Um, but all of this dates back to the case, this case that I was originally talking about, the Belsky versus Kapos case. Um, so yeah, and also they're gonna I think the Supreme Court is gonna have a hearing in March 31st, if I'm right. So we'll see what's happened, what happened by then, because it's still in the middle of the semester, and I'll probably talk about it after we have some kind of result after that. Thanks for watching. I thought I